I'm Christy Blakely. I'm the Executive Director of Family Voices Colorado. We advocate for children with special health care needs, and I want to welcome the families attending this webinar. We know it's difficult for families of children requiring private duty nursing to provide care and to appeal a denial. It is time-consuming and frustrating to appeal. This webinar is not only to assist the families needing to appeal a denial for private duty nursing, but it is to provide resources and the agencies to go to for support when you're in the process of an appeal. You're going to hear a lot of really great information, and I want to welcome you again. I'm going to toss the ball to Bethany Prey.
I'm Bethany Prey, and I'm presenting today for the Colorado Center on Law and Policy about home health and private duty nursing notices and appeals. Our contact information is on this slide. Me llamo Bethany Prey y soy directora jurídica del Colorado Center on Law and Policy. Hemos grabado una versión de esta presentación en español. Si prefiere escuchar en español, utilice el enlace en el chat. Next slide, please. Welcome again to everyone. Our agenda today covers notices for Medicaid home health services and appeals and leaves time for questions. We have several objectives for today's training. At the end of this training, you will be able to understand the information on your notice, know what to consider when deciding whether to file an appeal, understand appeal timelines, understand how to file an appeal, and know who you can ask for help. First, notices. Every decision about eligibility should come to you in a notice of action. Open this letter as soon as you get it. It's a good idea to keep the envelope so that you have the postmark date too. This notice is considered final, even if your home health agency wants to ask the state to reconsider its decision or to allow a doc-to-doc between your provider and the state's doctor. You can file your appeal while the home health agency pursues the reconsideration or doc-to-doc. If you wait until after the reconsideration or until after your doctor has spoken to them, you could miss the window for getting continuing benefits. Next slide. Every notice of action, every one of those letters must be dated at least 10 days before the action will take effect, must identify the date of action, and that's the date the decision will take effect, must give options for getting the information in another language or in another format if you have a disability, must give the decision, must give a clearly written reason for the decision and the regulation or rule that supports it, and must explain appeal rights and notices. Your notice may look like this. The notice date is the date of the letter and should be the date of the mailing. If it took a long time to get to you, the envelope may help prove that it was mailed late. The decision should be described in the first line. Here it says the request was partially approved. The date of action is the date the change will occur. The date of action in this notice is the same as the start date. The program rules that govern the decision that was made always begin 10 CCR 250510. And we'll tell you later in the presentation how to find out more about the rules. The EPSDT rule is about the extra benefits that children are entitled to. We'll also explain a bit about that. And the reason is a plain language explanation of why the service was denied or why it was reduced. So why is the notice of action so important? Every person enrolled in Medicaid is entitled to due process, meaning that you must be provided with notice and an opportunity to appeal or have a fair hearing. When a notice is mailed, the appeal clock begins to tick. This means you need to decide soon whether or not to appeal. If your notice does not have information that helps you understand the state's decision, what will happen and why, and how to appeal, your notice may be legally insufficient or inadequate. If you are already receiving benefits and the court finds that notice is inadequate, you will be able to keep your benefits until the state gives you an adequate notice. Okay, let's check for understanding on notices. First question, how and when should I find out about a service reduction or denial? You should receive a notice of action dated at least 10 days before a change in services. Next question, should my notice tell me why I was denied a service? Our answer is yes. The notice should give a plain language reason for the denial. You can also see which rules the state has cited, and those rules can also help explain why a service was denied. Right, next, appeals. All right, I got my notice. How do I decide whether to appeal? First, it's important to consider how quickly I must decide whether I want to appeal. Now we're going to talk about the standard timing here. However, at the end of the presentation, we will talk about a special process that is in place right now for children's certified nurse aid and private duty nursing services. It's best to make a decision about whether to appeal right away before the date of action, that was the start date on that notice, or less than 10 days after the notice date, whichever is later. Filing within 10 days or before the date of action will allow you to get continuing benefits. If you appeal later than that, but no more than 60 days after the notice date, you will still get a hearing, but probably won't get continuing benefits. You can appeal up to 60 days after the date on the letter. Understanding the reason services were denied. Read the reason and the detailed explanation of why services were denied. These are some reasons why services can be denied. The service is not medically necessary. For private duty nursing, it may say the request does not demonstrate that the client is technology dependent. For certified nurse aid services, it may say the request or specific task does not require skilled care. Or it may say supporting documentation was not provided or was not sufficient. Okay, finding the rules that are cited to support the denial. First, read the rules that are cited. The state passes rules that define Medicaid eligibility and most Medicaid benefits. You can look up the state Medicaid rules here at this link. And we've cited that on the slide. Now, understanding the rules that are cited to support the denial. More than one rule will probably be cited in your notice. One rule should describe eligibility for the particular benefit. Benefits like speech or home health nursing have their own sections of rule. Two rules will always apply if a child is denied a service or has services reduced due to medical necessity. 10 CCR 250510 8.076.1.8 is the state's medical necessity definition. And that's at around page 75 of that PDF document that you can link to there. There's also the state's description of the federal benefit for children called Early and Periodic Screening, Diagnostic and Treatment Program, or EPSDT. And you would find that one at around page 78 on this second link. Children are treated differently and have more flexibility because giving children the benefits they need early on when they're young can help improve their functioning as adults. So they get greater flexibility. Now ask yourself some important questions about when deciding whether to appeal. Do I understand why the service was denied or reduced? Do I think the service would improve my child's condition or help my child maintain function? Do I think that help from someone with a requested level of training or professional expertise is necessary? Do the program rules seem to say my child should be eligible for the service? And if the program rules seem to say my child should not be covered, do I think an exception should be made? Help, I still don't understand why the decision was made. If you still don't understand, talk to your home health agency, reach out to an advocate, and after you file an appeal, you may get a call from the state's appeal navigator. You can use that opportunity to ask them to explain why the decision was made. So why appeal or why not? Yes, you could appeal because you need to get services restored. You have no other way to get this kind of help. You think the state made a mistake and didn't understand the facts of your case or apply the law properly. Or no, don't appeal. If you think, in fact, the state's decision was correct, you don't think your child needs those services, and you have a way to get a different service that could be equally helpful. Remember, the appeal should usually be filed before the date of action or within 10 days of the notice. Just a reminder there about your timing. That's fine. Thanks. Go ahead. All right. So if you decide to appeal, what's next? You can file an appeal by sending a short letter to the Office of Administrative Courts or submitting a form. You don't have to assemble a lot of documents before you appeal, and you don't have to know exactly why you think the decision was wrong. You can also withdraw the appeal later if you change your mind or come to agreement with the state. So filing an appeal. Your letter or form will need to include the following information. If you use the form, you can find it on the website for the Office of Administrative Courts. We've included that on our guide. We have a guide that we'll supply you with. You'll need what is called the case initiation form. In the form or letter, you would include client name, address, and Medicaid ID number, a statement that you disagree with the enclosed denial, a request for accommodations if needed, a request for a face-to-face hearing at the Office of Administrative Courts if desired, a statement that the client wants benefits continued or does not want benefits continued, and if you received a notice, attach a copy of your notice to the letter. And just a reminder, again, if you couldn't file quickly because the notice was late or didn't arrive, or you were unable to due to illness or absence, you can still request continuing benefits. Now back to what you need in your appeal letter. After you submit the appeal, call the Office of Administrative Courts to make sure they received it. Next slide. Submitting the appeal. To send in your appeal, follow the information on our guide or use the court form, and then again, call the court to confirm receipt. We'll also post a copy of the appeal instructions so you have them in our guide. Next. All right, so a check for understanding on appeals. First question, how can I understand why a service was denied? You can read your notice to see the reason given and look up the rule that was cited. If it still isn't clear, you can ask your home health agency or an advocate. Next question, if I want to appeal, can I wait for a few weeks to decide whether to file? If you want services to continue during an appeal, you need to file an appeal quickly, within 10 days of the notice or before the date of action. If you don't want services to continue, you can file anytime up to 60 days after the notice date. And again, we'll talk about a special process at the end. If I file, do I need to have all my medical documents assembled first? No, you can assemble documents after you file. So after you file, getting a head start on the hearing. A hearing gives you the chance to offer facts and point out laws or rules that help prove why you or your child should get a service. It can take time to collect documents, and these pointers can get you started. What documents were submitted when the service was requested? You can ask your home health agency to send you those documents. What medical documents, letters, or school documents would help the judge understand why the service is needed? You can reach out to people who know your child's needs and ask them to write a letter. The opinion of a doctor can be persuasive. Can a doctor or provider testify for you? You can reach out and ask them to testify by phone or in person, or to write a detailed letter in your support. You should collect any documents that you want the judge to consider so that you can provide them to the court and the state before the hearing. So right now, there is a change that involves when your benefits will end or decrease and how you make sure that benefits continue during an appeal process. The department has created a special process for the pediatric, certified nurse aide, and private duty nursing cases. Everyone who is denied services or whose services are reduced will have an extra 60 days of services after the date of action. If you don't appeal during that time, benefits will end after those 60 days. Usually, you have to file your appeal right away if you want to make sure that benefits will continue through the several months it usually takes to complete an appeal. But for now, CCLP has been told by the state agency that as long as you appeal during the 60 days, you can have benefits all the way through the appeal process. We would still recommend that if you know you want to challenge the denial of benefits, that you file your appeal as soon as you can.